fun. I mean, you know, like.
I don't know what. Hello. If you've got any room, John insists on sitting at the table. It's been incredible for him. It's moved down. Well, it's too big for us. Oh my God, every single person said, well, you know, I used to be, but you know, I'm not speaking on behalf of.
Well, I'm to the right of my colleague here.
Entirely.
I am actually speaking for being.
Speaking on behalf of very important people, including myself. How self-referential can you get?
I mean, are you asking how meta can we get?
So John, I'm teaching in this part, but is it true that meta within there's an ecosystem theory for the staff?
Better not be on this.
All right. Then I had someone just say the case that these newspapers are getting together to collectively guard against the isn't that anti? Isn't that a catchphrase to the competition? I said, yeah. Wait, really? We're supposed to talk about it.
Supposed to talk about it.
I know, yeah. Are you involved in my company? Because that's right up your lane.
Yeah.
I did. Oh, we should have done this in virtual technology. The last one.
That's true. In fact, one of them.
What's that?
We should have done the whole thing with VR goggles.
Green and red.
Oh my God. This is remind us. Yes. No, I just had the piece of paper. With you scribbling. notes.
I haven't reached it at all. And that one was bad.
Well, that's very. I have like this. I do this. See, I got the. Smart.
I mean, you got.
And then they come up to me and I'm like, let me go behind the podium and really know what I'm dressed here.
I was just gonna, get up and do like a take 10 or a comedy showcase. All right. Thank you. You've been a wonderful audience. Thank you. Good night. Tip your leaders.
He read the opinion, I think he got like 40.
Elettra. You can pronounce it. I am absolutely.
You want to call this Spencer? Yes, that would be slander.
99 stars and another one.
Then. Good, because I have shurikens in my bag.
I remember that was my favorite.
So,
Use weapons.
huh? I don't need to. It's fun. My newest one's a Quandale, like long. Okay, we're gonna get started. We're the last thing between you and drinks. But it's an important panel on, as I call it, the potential and partial panel, the potential competition doctrine and partial acquisitions. And John was saying earlier how he skipped vertical. When I taught antitrust, skipped potential competition, even though I had written on it. And twice. Was giving up all hope and ever seeing the doctrine again. And then all of a sudden, voila. So we have a distinguished panel of folks. In terms of efficiencies, I'm not going to introduce John again because we already know who he is. I will recommend one of his articles to you, The Output Welfare Fallacy, a Modern Antitrust Paradox in the Iowa Law Review. You should check that out. Next to him is Spencer Waller. He's the John Paul Stevens Chair in Competition Law and the Director of the Institute for Consumer Antitrust Studies and a professor at Loyola University, Chicago. He's author of hundreds of articles and several books. And in 2022, he was the Senior Advisor to Federal Trade Commission Chair Lena Khan. The articles I'd recommend from him are include, there's many, Lasting Change in Competition Law and Policy. And if you just want something fun and relaxing to read, the ever popular A Pop Culture Guide to Antitrust. And then next to him is Elettra Bietti from Northeastern Law School. Is an expert on regulation of digital technologies, data and digital platform intermediaries. She holds an SJD and an LLM from Harvard Law School and an LLB from the University College London, and a postdoc diploma in IP law and practice from Oxford University. I would recommend an article from her called Structural Digital Platform Markets, Antitrust and Utilities Convergence in the Illinois Law Review. Next to her is Maurice Stucke at the University of Tennessee Law School, former DOJ attorney. He's testified before multiple governments and intergovernmental agencies, including the World Bank, the United Nations, the European Commission, and last but not least, the Federal Trade Commission. Okay. And you served time. I should finish that sentence. As a senior advisor to the Federal Trade Commission during the Biden administration. It's important to take breaths. Next to him is Jack Kirkwood from the Seattle University School of Law. I can't overstate his importance and contributions to the FTC. He set up the FTC's first antitrust policy planning office, and later managed the evaluation office and the pre-merger notification program. You should check out two of his most recent works, Reforming the Robinson what's this law? Reforming the Robinson-Patman Act and Competition Policy International, and his other article, Tech Giant Exclusion. John Newman insisted on monopolizing the time, so he'll get 10 minutes. And then our panelists will follow suit with 5 minutes each. Pass them a mic. Yeah, I'll sit over your chair.
All right, and Darren, who is a judo expert, is that right? Has threatened physical violence if I go over 10 minutes. So kung fu, there we go. Even scarier. All right, so I'll keep this tight, short. I wanted though to do a little bit of setting the stage again, kind of like we did with the vertical merger discussion this morning. So rewinding the clock to 2021, let's say January 1st, no US antitrust enforcer had ever tried to block a single acquisition by a big tech company, ever. Something like 5 companies, I think, had snapped up over 1,000 other companies, and there had been 0 ex-ante merger challenges to those 1,000+ deals. Before 2021, we already talked about this morning, the FTC hadn't filed a litigated vertical merger challenge for some 40 years. Previous administrations, I mean, both FTC and DOJ, had filed one litigated actual potential competition merger challenge and 0 perceived potential competition merger challenges, again, in about 40 years. In that one challenge, the Steeris case, the FTC had affirmatively argued for that we should have to prove that the acquirer was one of only a few possible entrants, which certainly goes without saying would be an incredibly difficult burden to carry. Maybe we could have done it in that case with a different judge, but it would have really set up a difficult hurdle for us to climb in future cases. And that was our own argument, our own briefing said that was a requirement. Going back even further, in the 1980s, when Jim Miller took over the FTC, they didn't just dismiss all of the pending vertical and potential competition merger cases. Instead, they issued a bunch of opinions, commission opinions, finding against staff, against the ALJ, saying there was no problem. And really, in one of the more staggering instances of what I sometimes call lawless antitrust, the commission issued an opinion in this Bietti case where there's literally just, we think the law should be X, so we're going to make the law X and find against the agency. Among other things, they identified a standard that departed wildly from the usual merger standard, despite the Supreme Court saying, hey, you're supposed to apply the same standard. And they said to win a potential competition case, you commission would have to prove, or I guess we commission, would have to prove clear proof that the acquirer would have entered but for the merger. I'm looking at Bob Land, who's hopefully just horrified by such a thing. So that was the landscape that we were marching into. Enter Meta, they're on an acquisition spree. It's pretty clear they're trying to buy up basically every part of the VR stack. A complicating factor was that Meta, looking at this from the outsider, which I am now, from the outsider's perspective, it's possible that Meta was using a kind of open first, closed later strategy, which they had used to dominate the personal social networking space. That makes it harder to convince a judge that there's going to be foreclosure because you're in the open now phase of the strategy, right? So that's the landscape. That sets up a showdown, FTC v. Meta. And Meta tried to use that entire landscape against us in litigation. One of the themes they tried to develop is, hey, we just want to grow the entire VR ecosystem, open now, right? That makes it really hard to prove foreclosure. They pointed to hey, this is the first ever challenge against big tech. This would upend the entire Silicon Valley funding ecosystem. This will be the end of innovation as we know it. The VC funding will dry up. The sky is falling. They called potential competition law dead letter doctrine. They even filed a motion to dismiss, saying these doctrines didn't survive Twombly. So Twombly implicitly overruled all those cases that use potential competition. They argued Chair Khan is biased because she's, I guess, actually carrying out the agency's congressional mandate instead of just sitting back and letting us buy another 1,000 companies. I think our case team did a pretty outstanding job fighting this real multi-front war. Won a motion to strike. Meta's, I guess it's in the afternoon. We can curse if we want. Absolute bullshit arguments about the chair being biased, about the agency being unconstitutional. It's not easy to win a motion to strike. We did that. Yields really useful precedent, obviously, for us going forward. People didn't pay as much attention to that, but within the agency, we absolutely did. And I think that the team pulled off a really professional PI hearing, got a bunch of damaging concessions from Meta that I think they did not like having to admit in an open democratic setting. And we won on the motion to dismiss. The judge endorsed actual potential competition as a theory for the first time in like 40 years. So that's a tool that's now officially back on the table. Endorsed perceived potential competition as a theory, again, for the first time in like 40 years. That's another tool that's now back on the table. And there were a bunch of holdings along the way that I think kind of flew under the radar, but again, is super, super useful to all sorts of enforcement actions going forward. Like, for instance, the idea that you can bring a case in a nascent market that's seen actual new entry recently and exit and volatility of market shares And yet still it's enough to shift that burden for you to just give a judge HHI, right? That's exactly what we did. I think Rebecca called this a kind of punk rock antitrust, which I really liked. Yeah, it's stripped down, it's simple, it's easy to do. I think Hal did a really nice job of explaining it to the judge. But it's nice because it's not a super convoluted theory for the economist to have to try to defend. Obviously, I think it would have been really nice to win the whole thing outright, not just the motion to strike and the motion to dismiss, but also the motion for a preliminary injunction. But again, I think there's some real value to bringing a case like this, and it really has, I think, revived and breathed life into this area of the law in a way that, man, Meta called this dead letter doctrine. I don't think they were right in terms of like actual precedential like life that exists out there, but in terms of like how often were these cases getting brought? Were they being taught in antitrust classrooms? They had a point to make that this doctrine, if it wasn't dead, had been, I think, left in the tool, mixing metaphors, left in the tool shed to kind of rust. And I do think it's back on the table in a way that's really exciting. It shows up in the merger guidelines. I think that's one of the guidelines that drew the least amount of criticism when it dropped. And that's because we had actually brought a case and gotten a judge to say, yeah, this absolutely is a viable doctrine. I don't think this will be the last potential competition case that this administration brings. I think they are going to bring more. And when they do, they aren't going to have to fight the battle on all of those fronts that I just laid out. It won't be the first case to ever challenge a big tech acquisition ex ante, right? It won't be the first perceived potential or actual potential competition case, in 40 years. And so I think there's a lot fewer hurdles to jump over now. So I'm hopeful that although it won't be easy, these cases are not easy, it'll be a hell of a lot easier than that one was. So with that, Darren, did I stay under time?
Yeah,
Whew.
before you go, I
All
have a
right.
question.
Yeah.
So under the draft merger guidelines, and if you take Meta with that, and the court looks at those merger guidelines, you win?
The one area where Judge Davila,
Sorry.
yeah, that's a good one. I think the one area where Judge Davila got hung up and got it wrong, candidly, was when he got to that reasonable probability question. So the guidelines use this term reasonable probability. That's true to the Supreme Court, but reasonable is the squishy word. So I think it is still going to depend on the judge. It's going to depend on how well you can advocate, explain the case. So it's hard to say. It's hard to say. I think if it were not the first big tech case, because that's a big ask, right? I think if it weren't the first big tech case, the first case to trot out the perceived potential competition theory, the first one where a judge endorsed it, I think it could easily come out differently. But there, it is fair to point out that the word reasonable, I think, is still in the guidelines. There's still some wiggle room there. So hard to say, but it's a good question.
Thank you.
All right,
Thanks.
get out of the way.
Okay. Hi, everybody. Although Darren, I appreciate you mentioning this. Although I did spend 2022 at the FTC as a senior advisor, I didn't work on anything relating to the merger guidelines. I worked on working groups relating to the Section 5 policy statement and the proposed rule banning non-competes. So I really didn't have anything to do with this and really didn't hear much about it other than from time to time folks expressing frustration. And I think I did attend some general staff briefing of an earlier version. It didn't look like this, and I don't remember what they said anyway. And I appreciate Darren's framing of this panel as the potentially partially panel, because my remarks are potentially interesting and partially correct. So let me just start with a couple reactions. I think again, just as an outsider for this project, I viewed these revisions of the merger guidelines as having two main kind of goals. One was to articulate the vision of the current agencies and agency heads. And also, we kind of alluded to this in some of the panels, that just the zeitgeist around the agency is that, not every single case
should require multi-million-dollar, economic experts in order to win when the evidence otherwise supports taking action. And I think those are themes that are articulated anywhere, but I just think those were important things. And in my experience, as a very, very junior lawyer at the Justice Department, I came in after a clerkship 1 year after the 1982 merger guidelines. So I see three audiences for these types of guidelines. One is the staff. The staff needs to know what the front office cares about and what language to use in communicating with them, yes, no, whatever on a staff recommendation or going forward. Obviously, the parties. The parties would be committing malpractice if they spoke in a language different than what is in the guidelines where the agency says, here is what we care about and how we are phrasing the conversation. And then third, the courts. And again, obviously, you want the courts to buy this view. I'm just suggesting they're not the only important audience for this kind of exercise. I view this draft that we're talking about today as a continuation of a project that I think started in 2010. I think this is largely consistent with the content, not the organization. But one of the things pre-2010 was that courts, and again, your average generalist federal judge who doesn't have a background and doesn't see a lot of these cases, and frankly resents these cases because they're big, they're difficult, and they interfere with the other 400 cases they have to process in most big metropolitan areas. They kind of like the fact that the merger guidelines were cookbooks. You did this, generally speaking, you did market definition, then you did power, then you did theories of harm, then you did some other things, you thought about efficiencies. And that's something that smart judges, know how to do. 2010 began the project of this is not a cookbook. It more or less said that. It sort of said, you don't have to do this in any particular order. If you remember, the 2010 guidelines began with competitive effects and started the conversation that this is what we care most about. And, they don't say it this way, but there are many paths to the Buddha. And, now I heard other people saying this today as well, but, I really do believe that this is in a good way, choose your own adventure. This is what we care about, competitive effects. And there are a bunch of different ways to get there. And then there are a bunch of different special type situations where any of these could apply. And I think this is decentering market definition, decentering efficiencies, and focusing on what the agencies care the most about. So in terms of this particular panel, I want to make the argument that I think actually what John was talking about, I think the frame of nascent competition is a better frame than potential competition. I have no objection to it. I just like it better as a former litigator. I think it makes more sense to judges. And I think, until recently, there's been a very poor track record on potential competition because it's hard to explain for two different reasons, in my opinion. I think the government has often just gotten screwed on these cases, but I understand, I think, why judges are reluctant to go down this path and more eager to do nascent competition, which I think makes more sense. One is potential competition makes perfect sense. There is some entity that's exerting a present impact on a market and they're being taken off the table as a player. My only problem is what's the half-life of that? How long can you be a potential, perceived potential entrant and have this continuing influence where you're not actually coming in? At some point, people who work in this space are going to go, I guess they're not coming. And then they lose, and then you could acquire them. So it makes sense. It's just like a radioactive isotope that quickly begins to degrade in terms of how powerful it is. I think the other part is the actual potential entrant makes a lot of sense. I think it's a bad thing when a serious actual potential entrant. I have trouble squaring it, and this maybe goes to Bob Land's concerns with textualism. I have trouble, I understand the arguments, but I think I think judges have trouble seeing how someone who's not in the market and then is taken off the field and for some reason isn't perceived as an important current force, how their elimination tends to substantially lessen competition or tends to create a monopoly. I understand that down the road in the future, had they entered, then been acquired, that better matches the language of Section 7. All I'm suggesting is the way to tell that story usually works better as a nascent competition story. It makes sense in Microsoft, where, you know, why were they doing all these things to harm Netscape and harm Java? Because they viewed them as nascent competitors, and you had to stop them, in this case by exclusion, before they got big. Or why is there litigation against Facebook's acquisitions of Instagram and WhatsApp? Again, you can talk about potential entrant theories. I think the nascent competition story is a better way to do it. And I'm not saying every single case can be described that way. I just think in general, it's a better frame. And I hope going forward in final drafts and case selection that, you know, that's just something that is to be considered. Just a couple other quick comments and then I'll be done, Darren. I'm not sure my exact time. I think in the guidelines, I don't know if other people are going to talk about this. I think the serial acquisition stuff is extraordinarily important. I don't frankly know how often it's going to come up in the tech space and the platform space, but there are already pending cases that the FTC has brought involving anesthesiologists in Texas, where serial roll-ups are going on and have been challenged as both a Section 7 and a Section 2. The CMA has a case or investigation, I don't remember, involving veterinarians, again, where a series of acquisitions over and over and over again are resulting in substantial market power in whole swaths of the UK, as I understand it. So finally, the other thing I like about this emphasis on potential competition, nascent competition, and partial acquisitions and serial acquisitions is I think these guidelines have the effect of better aligning Section 7 with the nascent competition stories that are well accepted in Section 2. It also, there's some footnotes and things where these guidelines are trying to sync better with the unfair method of competition under Section 5 of the FTC, which also has language and examples relating to roll-ups and other things involving nascent competition. And also, I'm in no way saying this is deliberate, or I have no way of knowing if it was even discussed. The changes you see in these guidelines, including entrenchment, all the things we're talking about in this panel, also begin to nudge US law a little bit closer to some of the prevailing international standards relating to the abuse of a dominant position. And I think that's kind of cool. So I'm gonna stop there so I have any time reserved.
No, I'm standing again. You mentioned the policy statement, the 2022 FTC policy statement. Without stepping on any of your former employer's toes, you know, can you comment a bit more about sort of the linkages between that statement and the merger guidelines?
Yeah. If you haven't looked at it, it's worth looking at. It's about 10,000 words or so, 16, 17 pages. The basic structure of it is to analyze in the same way that these guidelines kind of cite court precedent and for the Section 5 congressional intent and legislative history. It's the first comprehensive statement that the FTC has produced on the meaning of unfair methods of competition, which include everything that violates the letter of the antitrust law, incipient violations, which obviously share some common DNA with Section 7, and this notion of unfair methods of competition, which violate the spirit of the antitrust laws. And the way the statement is structured is a lot of legislative history, then a discussion of what is a method, like a method of competition, and then what is unfair. Then it talks a little bit about when efficiencies will be considered. And there's a little disconnect, by the way. In the policy statement, they talk about it as an affirmative defense. I think that is also a better frame. And I think that makes it crystal clear whose burden it is. It is the defendant's burden in any normal sense of civil litigation and under that policy statement. And it does talk about the last section of the guidelines has lots and lots of case cites and consent decrees and other things showing almost every every category of thing that is held to be unfair methods of competition since 1914 to the present. And it has examples of nascent competition. It has examples of serial acquisitions, including a consent decree in 1990 by Vons. Yes, that Vons, but not that case, because in the 1980s, they bought a bunch of small grocers and grocery chains in Southern California, 5 or 6, 10 or 20, none of which would ever be Hart-Scott-Rodino filings. And they would spin off 1 or 2 there, and then they'd go to the next town and buy 5 and sell 1. And they were gradually rolling up and creating a position of strength, if not dominance, in Southern California. And I'm not sure that any one of those would have violated Section 7. However, a series of acquisitions, they were challenged and they settled. And there's a consent decree that doesn't admit anything, but is essentially based on an unfair method of competition theory.
Thank you.
So-
Elettra.
Yes, so thanks so much, Darren, Hal, and everyone at the Utah Project for having me here. Very exciting to be in Utah for the first time. So fun fact, my first case as a junior antitrust lawyer was actually a merger case involving a chemicals company that is based, I think, really close to here. So in the spirit of being on the potentially partially panel, I have approximately 4 things to say, which are not necessarily within the scope of like the theme of the panel. So I'll say 3 and then I can stop and maybe go to the other one in Q&A. So first, I haven't heard many of these critiques in this particular room, but I think there are many critics of the merger guidelines that have argued against this kind of shift, the paradigm shift that they represent, arguing that they increase friction, that they increase costs, that they increase kind of the bureaucratic apparatus around M&A transactions. And I think it's important to offer a few rebuttals or a few responses to those critiques. And so I'll say, first of all, most of the large transactions that will need detailed scrutiny under the new proposed guidelines already go through multi-jurisdictional filings in a number of places in the world that take a far longer time probably than scrutiny would take in the United States. Some of the smaller transactions would probably not be scrutinized as closely under the new merger guidelines. So I don't think it would represent a significant bureaucratic burden on companies. As already mentioned today, I also think it's really important to emphasize that we're dealing with 2 severely understaffed agencies, which will very likely not over-enforce in the sense of scrutinize every single transaction that is notified to them, but rather they will exert some kind of selective prioritization mechanism. They will choose cases. And so in that sense, I think what these guidelines are doing is they're giving them powers, they're giving them scope for action, and they're giving them some flexibility to investigate transactions that might matter to consumers, to workers, to competitors, and to society more largely. And third, and perhaps more importantly, I think there's a kind of bigger point about the relationship between freedom in markets and regulation. And I think very often we tend to assume that companies have a sort of primitive, natural freedom to engage in unhindered transactions in marketplaces. And I think that assumption is wrong. Firms are creations of the law. And so their contractual agreements and business strategies, including M&A strategies of expansion, are legitimate grounds for legal intervention and public scrutiny. And so the default that we're operating in when we're considering the impact and the justifications for these new merger guidelines is not absolute unhindered freedom for companies, but it's rather that whatever firms do in markets needs to serve the public interest. So this I just wanted to put on the table. I have another kind of set of points about the fact that the guidelines, including guidelines 1, 2, and 4, seem to ground merger control in structural considerations, and this has been discussed throughout this conference. And also this idea that Susan Atty mentioned this morning about the focus on risk and risk assessment. And I think there's something really interesting when I read these guidelines. I see a sort of shift that in other disciplines could be described as a shift from a cost-benefit analysis to a precautionary principle approach. And so maybe we could talk about these guidelines as a sort of precautionary principle for antitrust. So it's no longer waiting for harm to manifest itself and acting on it, addressing it after the fact, but instead trying to avoid risk ex ante from an earlier point in time. This philosophy, as many of you have argued, seems in line with the underlying philosophy of Section 7 of the Clayton Act, the emphasis on a substantial lessening of competition and the emphasis on monopoly. So as Bob Land emphasized this afternoon, or this morning, I can't remember, the importance of advancing a relatively decentralized and distributed market where plurality of competitors can challenge each other, and also the importance of fighting larger concentrations of commercial power, monopolies, and the possibility of exclusionary behavior down the line later in time. And so I believe that the kind of current default hands-off approach to purchases of nationed startups by tech companies, for example, doesn't necessarily reflect this underlying philosophy, and that the new merger guidelines do a better job at bringing to the forefront of policy the precautionary approach that might actually be justified. Third point, I just wanted to comment briefly on the interaction. Am I going completely over time?
Keep going.
Brief comment on the interaction between merger control and other market regulatory efforts. So first, I have to say I really liked the first illustration in Guideline 13, which hasn't really been discussed today. But the comment is that mergers could lessen competition if they enable firms to avoid a regulatory constraint. I think we should have an entire conference on that because I'm not sure exactly what it might mean, but it seems to me that every time firms merge, they're actually avoiding some regulatory constraint. And so I really think there's a lot of space for further thinking there. But the second point I wanted to kind of highlight here on the relation between merger control and market regulation is around Guideline 5, which was discussed this morning, which I interpret to basically prohibit or disincentivize the creation of platforms or the creation of infrastructural goods through a merger transaction. And I'm not sure I like this, actually. So surprisingly enough, I actually think that platforms or infrastructural goods could be very good for society. And so disincentivizing the ability of firms to merge perhaps among complementary business models to create a platform might actually be going too far. And so I kind of want to say that I see this guideline as a second best. I see it as a guideline that is justified in the absence of regulatory checks and balances that can make the private owners and managers of infrastructural goods more accountable to the public. So in the absence of a regulatory framework that makes it possible to regulate infrastructure and platforms, we need merger control to do the job of preventing platforms from existing. But the first best would be for companies to be able to come up with infrastructural types of business models and for regulatory apparatus to be in place that can actually make sure that those infrastructures are aligned with the needs of the public. So I'll stop here. I have a few comments also on minority interest and partial acquisition. I'll keep them for later.
So you mentioned the bundles, well, you didn't say bundle of sticks, but you said, you're not necessarily, I'm paraphrasing you badly, entitled to use your property in any way you choose, including, in terms of mergers, which is strange for me coming from Texas, which is a stand your ground state. But you mentioned that the guidelines were a second best. So is your first best perhaps legislation? And would that be sufficient to keep us up with the Europeans and other merger control?
Yeah, so I've done some work on the American Innovation and Choice Online Act, or other types of European DMA-like reform initiatives in the United States. And I think they would be welcome. I don't think of them as substitutes to antitrust. But I think in some cases we might, so I do some comparative work between Europe and the US, and I think different regions warrant different analysis on this question. In the US, I think the antitrust enforcement apparatus is certainly more developed and more suited to tackling a lot of these issues. And so I understand why Guideline 5 exists. In a different kind of context, I would be wary of Guideline 5 because I do think that it might impede some valuable innovations. And I know that we've been talking about this term innovation with skepticism. I myself think of innovation with a lot of skepticism. But I think there might be some valuable innovations that entail some level of infrastructural good that somehow, allows managers and owners of that good to exclude potential customers, to exclude other players on the market. And that's not a good enough reason perhaps to not have that good. It's a good enough reason for saying we should allow private actors to develop that good, and then that good should actually serve the interests of the public. And whatever, and what that entails from a legal perspective is very challenging, but that's my view of that.
This has all been an incredible behavioral economics experiment. I'm playing on Maurice Stucke. Who's next? No, just kidding.
All right, well, thank you so much for inviting me. Maybe credit after my comments, but two things I want to raise. I want to raise first something that's not in the guidelines, but I think should be. And then second, something that's in the guidelines, but will courts listen? So the first thing is what's not in the guidelines. You don't see any mention of the word ecosystems, right? But should the agencies and courts be looking at ecosystems? So here's a quote from Google's CEO that he told investors in 2019. His company builds ecosystems, not products. If you want, if you look at an ecosystem like Android, this is what we do. And so that's going to be a focus for us. And then the Facebook Meta case, according to the court, Meta repeatedly stated that VR dedicated fitness apps constituted a distinct market opportunity within the VR ecosystem due to their unique uses, distinct customers, and distinct prices. So our product markets yesteryear, platforms are 5 years ago, and our ecosystems where we need to be today. And you might say, well, what are the benefits of looking at ecosystems? We may be seeing things that you're not going to see when you look at narrowly defined markets like super premium ice cream, right? And you can see the importance of data, the increase in entry barriers, innovation, the impact that that could have, and the like. So one of the questions then is, all right, let's have ecosystems. How do we operationalize it? How do we define it? And we can do that during the Q&A. I have some thoughts about that as well. But this is not something strange. Think about the Google Fitbit merger. The European Commission was concerned, quote, when it talked about how the data-driven merger could strengthen Google's hold over the entire ad tech ecosystem. So one thing is, was there an ecosystem approach in Facebook within? And we've got several people here who were involved in that. And might have that offered another window in looking at that. The second issue is, will the courts listen? So The draft merger guidelines restores the incipiency standard and trend towards concentration. And the incipiency standard is mentioned 3 times, and that's really important, right? It's very hard to predict, even for unilateral effects, what will happen post-merger. It's going to be even harder for partial acquisitions, potential competition concerns. So incipiency is going to be key. But many courts right now don't treat Section 7 as an incipiency standard. Instead, what do they view themselves as? Fortune tellers. Here's what the New York versus Deutsche Bank case says. Adjudication of antitrust disputes virtually turns the judge into a fortune teller. Deciding such cases typically calls for a judicial reading of the future. And this is not a good thing. The court says to aid the courts perform the murky function demands a massive enterprise. In most cases, the litigation consumes years at cost, running into millions of dollars. In furtherance of their enterprise, the parties to the dispute retain battalions of the most skilled and highest paid attorneys in the nation. In turn, the lawyers enlist the services of other professionals, engineers, economists, business executives, academics, all brought into the dispute to render expert opinions regarding the potential pro-competitive and anti-competitive effects. And what happened in this case at the end? The court then turned to the tools that it was familiar with, reading the demeanor of executives. And in that case, it was a disaster. After that transaction was allowed, for several decades, mobile prices were going on a downward trajectory. After that case was decided, mobile telecom prices increased by a small but significant non-transitory amount, around 4 to 5%, and they have remained elevated. And this judge wasn't like some right-wing radical. It was Bill Clinton's appointee. And then if you look at the Microsoft Activision deal, court again mentions the incipiency standard and then goes right to what will happen post-merger. And that was the expectation on the court. And there again, that was a judge appointed by Joe Biden. So we've got this in the draft merger guidelines. But how do we operationalize the incipiency standard? And as John mentioned, courts love the brown shoe factors. I remember when I was at DOJ and I had to do this memo on differentiated products. One thing I found was that courts consistently went back to brown shoe, even though the economists within DOJ hated the brown shoe factors. So one concern that I have is, what is the point of entry going to be for a judge in looking at these draft merger guidelines? What's their point of entry? I mean, love them or leave them. The 1992 merger guidelines was like a Prussian march. You start off in step 1, go to step 2, then step 3, right? So should there be a reconsideration of recharacterizing these guidelines? Step 1, tell the court you are not a fortune teller. The standard isn't what will happen post-merger. You don't have to show that the merger will create a monopoly. That contravenes congressional intent. Step 2, assess whether the merger is presumptively illegal. You've got Philadelphia National Bank, you've got the brown shoe decision and vertical decisions, vertical mergers. Step 3, if it's not presumptively illegal, does it run afoul of the incipiency standard? And then here's how the incipiency standard would be applied in these various theories. And if courts are a lost cause, should we then be looking for a legislative response? Think about where Europe is going. It's moving away from the economic approach. I mean, the DMA no longer defines relevant markets. There's no efficiencies defense. You've got clearer presumptions about what's anti-competitive. And the DMA doesn't address mergers, but that's going to likely be the next step. And the good thing here is that Congress could step up. I mean, you have Senator Klobuchar has the Competition and Antitrust Law Enforcement Reform Act of 2021. And then you also have Senator Warren's Prohibiting Anti-Competitive Mergers Act of 2022. So what is we as a group? I mean, we don't like judges as fortune tellers, how can we reorient a debate? Well, maybe having a point of entry in the merger guidelines, but then also pushing far more on the legislative front. And so I'll leave it at that.
Okay, I'm gonna call you on this for a second. Well, first of all, apparently you don't like the guidelines because there's too much for a judge to consider, right? It's not as lockstep as the older merger guidelines. Instead of a step-by-step process, there's like 50 ways to block your merger, right? So, so what makes you think that Congress can write a law that could be implemented that would make a situation better that courts would adopt, given the court's reticence to, block mergers?
Yeah, I mean, personally, I like a lot of the things I saw in the guidelines. It's refreshing. But my fear is that a court looking at this is going to then say, what am I going to do with this? But no, I think if you look at Senator Klobuchar, first of all, you have a nice facts where you're going to say, this is the problem, what courts have done. They've disregarded the incipiency standard. Here's how we're going to restore the incipiency standard. We're going to add monopsony wherever monopoly is added. And we're going to do then is we're going to ban some mergers, and we're going to have strong legal presumptions for the others. And we're going to have very specific provisions. And then for some of these mergers, we're not even going to define the market. We're going to use on clear criteria of these type of firms, it's presumptively illegal. So yeah, I mean, I think the courts would then have to then apply.
Okay. All right, Jack, partial. Are you partial to partials? Partial acquisitions?
No, I'm going to switch the focus to common ownership. 7 years ago, Einar Elhaig published a call to arms. In an essay in the Harvard Law Review, he urged the antitrust agencies to bring enforcement actions against what he called horizontal shareholding and what we now call common ownership. As you know, common ownership involves equity investors who hold non-controlling shares in two or more competitors.
Sorry, Jack, can you move your mic? Someone in the back can't hear you.
Sure.
Thank you.
Einar's most powerful argument was that econometric studies by Azar and co-authors showed that increases in common ownership were associated with higher prices in both the airlines industry and the banking industry. And other scholars like Eric Posner here, Herb Obenkamp, and Fiona Scott Morton promptly wrote supporting articles. But today, despite the initial enthusiasm, there have been no enforcement actions and there's no enforcement program. The guidelines say they have concerns with common ownership, but they don't analyze it in any detail or set forth circumstances in which it might be challenged. So today, what I'm going to try to do in my few minutes is cover three things. One, identify what derailed this initial attack on common ownership. Second, describe the strength of the current responses. And three, outline possible circumstances that might warrant a challenge. What took the wind out of the initial sales was two things. One, critics said there was hardly any econometric support. There were only the two Azar studies, and they presented methodological issues. The second attack, however, may have been even more devastating. Critics argued that no one had shown how common ownership could have anti-competitive effects. Of course, common owners could orchestrate a cartel, but short of outright collusion, what were the causal mechanisms? Scott Hemphill argued that all the potential mechanisms were either implausible or untested. Lucian Bebchuk pointed out that big index funds get very small percentage fees, and he argued they would have no incentive to reduce competition among the firms they held. And Doug Ginsburg stressed that investment funds held shares in vertically related companies, which would undercut their incentive to reduce competition in the relevant market. Subsequent work, however, all that's happened since these initial attacks has made an attack on common ownership somewhat more promising. First, the econometric support is now much stronger. There are currently 15 studies that find increases in common ownership associated with higher prices. And there are now good responses, maybe not compelling, but good responses to the corporate governance attack. First, investment funds generally hold shares in competitors that are greater in value than the shares they hold in vertically related funds, restoring their incentive. Eric, I'm talking about common ownership, where you played such a significant role initially. Second, while the percentage fees that index funds earn are indeed small, the costs of restricting competition among the firms they hold seem to be even smaller. For example, when funds vote their shares, it costs no more to vote against directors who favor aggressive competition than to vote in their favor. Third, horizontal shareholders do have an array of tactics available to transmit their interest in reduced competition. For example, many funds acknowledge that they engage in regular communication with the management of the firms they hold, and they could use those opportunities to press for less discounting, less investment in capacity expansion, and executive compensation structures that put more weight on industry profitability than own firm profitability. Similarly, funds could vote their shares against, say, hedge funds that wanted to shake up the firm and make it a more vigorous competitor. In sum, the current state of the evidence seems to call for at least a somewhat more muscular approach to common ownership. So my suggestion is that the guidelines discuss it in more detail and outline the kinds of circumstances that may warrant enforcement action. Those circumstances should include the obvious structural factors, a highly concentrated relevant market, and substantial common ownership. But they should also include, in my view, some direct evidence of anti-competitive effects, such as evidence that increases in common ownership in this industry led to higher prices, and evidence that a common owner had taken some affirmative steps to dampen competition. Einer believes that you don't need that kind of direct evidence. The ability and the incentive of these big funds to restrict competition is enough to support a case. But this would be the first case. This would be a test case of a novel theory. And my sense is that it would be imprudent to bring it without direct evidence of any competitive effect.
So if you're advising a big index fund, and are you telling them that they can only hold one position in one relevant market?
That would be the implication. And indeed, Eric's article describes exactly how you would achieve that, how you would.
Okay, so is there any loss to diversification? Because you can have diversification outside of a market. You can also have diversification in a market.
Yeah, that's why they're holding the shares of multiple competitors. But the analysis of diversification shows that you get some 99% of the reduction in volatility just by holding one firm in each relevant market.
Okay, well, thank you. John, I want to go back to you, and I'm actually going to ask you to respond to Spencer's point about nascent competition being a better and more effective tool than potential competition. And I'm going to piggyback on that with a hypothetical of one of the problems of perceived potential competition, which is if I can view a firm as a competitive threat and I seek to acquire that firm, do I not find out in the due diligence whether or not they are whether or not they're an actual threat or not? In which case, if they're not, shouldn't I just abandon the merger?
I like that. All right, so Darren, I'm going to try to do a little bit of a bob and weave here, but I'm going to try to combine my answers and merge my answers to the two a little bit.
Will that be efficient?
It will be very efficient, I promise. So I think Spencer raised a really, really interesting point. Maybe just a couple of these are just off the cuff reactions. But one is the nascent competitor framing, I think can be a very, very useful one in litigation, but it does, I think, invoke for the judge a certain theme, like a litigation theme. And the theme is, I am seeing this young upstart as a threat to me, and that's why I'm acquiring them. I think sometimes that does fit the facts. Microsoft is the quintessential example, right? But sometimes it won't. And I think in a case like Meta Within, it would have been either a tough sell or like an awkward sell to frame the story as one of nascent competition, because I don't think we could have mustered evidence to suggest that Meta viewed Within as any kind of competitive threat. So I really think there are kind of two litigation themes out there. One is nascent competition, but I really think that potential competition, actual potential competition, has a really important role to play, both because sometimes it just is, I think, a more natural fit with the facts. I think it is a clunky label, and something like a lost chance of future entry might be more intuitive and maybe more intuitively appealing for a judge. But it has a really important, I think, expressive role to play. One of the things that it's easy to forget when you talk about an anti-merger statute like the 1950 Seller-Kefauver Act is that it doesn't just express Congress's negative dislike for harmful mergers, right? It also, and the Supreme Court has said this, expresses a positive preference for growth internally rather than growth by acquisition, for companies to actually roll up their sleeves, get to work, not be lazy, not just buy up the market leader because you can, but actually roll up your sleeves and get to the hard work of innovating, build something, right? Hire some people if you need to. An actual potential competition as a theory among the entire array, the 50 ways to block your merger that are laid out in the guidelines, that theory is the one that most clearly expresses that message. Build instead of buy, right? And it tells, I think, the companies, I think it tells the world that one of the values underlying the merger laws is not just we don't like bad mergers, but we actually have a policy preference for internal growth and actual potential competition. Build instead of buy is the clearest way to convey that message. Perceived potential competition, I tend to think of, Darren, as a nice like gap filler. I think of it less as kind of a useful standalone theory. You don't see a lot of standalone perceived potential competition cases even back in the day. What it can do for you, I think, in litigation, if it's done right, is it bridges the gap for the judge. One of the hard things in an actual potential competition case is like the harm might not arise for a little while. In theory, it won't arise until the company would have entered, and that might have been a year down the road, might have been a couple years down the road. It's a lost chance of future entry. The harm doesn't really arise until the future point when the entry would have occurred. Perceived potential competition, I tend to think of as a nice like, hey, judge, by the way, there's going to be some harm in the interim that's happening right now. So I tend to, it's not an afterthought, but a little bit. And so I think of it that way. And I think it's really natural for companies not to have it like super top of mind because it is less of a like core theory to my mind.
So Spencer, you all probably know this. Who wrote Marine Bancorp, the leading potential competition case? It was Powell, a famous Powell memo. So Spencer, your rebuttal?
Well, I don't have much of a rebuttal. I think John's mostly right, but I think the the third piece is entrenchment. I really think this is a super important part of this because it's another way of telling the story that there's somebody else out there who represents some kind of a threat to the continuing dominance of a firm. Now that involves some factual things about market share and structure of the industry that won't always be present. But, I happen to think Procter & Gamble got it right. I think it's a lazily written opinion by Douglas, who was never known for his, precision as a drafter. But the gist of it is right. You had a firm that firms can do a bunch of things to maintain their dominance or their market position, even if it's not quite at a level you might think is of dominance. One of them is exclude, one of them is buy, and the other is sort of marginalized. And you need different stories. And I mean by stories, I don't mean fables. I mean coherent narratives backed up by facts and an array of expert testimony. And I think you put together potential competition, nascent competitors, entrenchment. And again, just the agencies haven't done much of that since the late 60s. I was told point blank, we don't do entrenchment in 1983. And I'm not sure, I'm not sure that there's been much difference until very, very recently. And so, you find the one that fits the facts because that's the one that's most likely to win. And I think one other thing is this allows, sorry to say it, and I don't mean this personally, this is not going to exclude traditional economic expert testimony, but it is going to decenter it. And if you look at cases like Google, you're not going to just have an IO economist. You're going to have a behavioral psychologist talking about the power of default, marketing people, business strategists, maybe people from the press, customers, exactly. I mean, some of this are traditional witnesses, but you're telling the story, and whatever is going to convince a judge under the proper interpretation of Section 7, or even the fortune-telling version of Section 7, that you got a problem. And just one other brief comment. Every time, this is just something folks at the FTC said to me over the course of my year, even when I'm working on other things. It's an enforcer's perspective I've heard a lot, that when you don't get a merger decision right, you're just creating a conduct problem in case for later on. And, that's not unique to me, but it's certainly true for Facebook, WhatsApp, and Instagram. And it's certainly true for Live Nation Ticketmaster. So that's why this stuff is super important.
I've been thinking about applying to a college on the Eastern Seaboard that's very conservative and antitrust. So I'm going to ask the following question. Aren't these theories of harm stifling innovation? Isn't the whole point of these big tech markets so I could develop products to be acquired by Meta and other big companies? And so I don't mean to suggest I'm misunderstanding innovation, but Elettra and Maurice, if you could respond to that.
Sure. I also actually wanted to comment
Please.
or add something to this final interaction, which is I think there's kind of a broader landscape aside from the merger control guidelines, which we're talking about. There's a landscape of startup acquisitions that the last time I checked, there was a really nice chart that showed that the more successful the startup in terms of like what round of funding the startup is at, the more likely it is that the startup will be acquired, right? And so there is kind of whether or not those startups will become threats or become competitors to incumbents, there is a landscape where startup founders and entrepreneurs begin their professional life thinking they want to be acquired by some bigger entity at some point down the line. That leads to a specific kind of ecosystem that is concentrated, that has all sorts of features, right? Whether or not it's necessarily a question of, is that entity a potential competitor? Is it a nascent competitor? Is it just an entity that will exist as a competitive constraint or that will diversify the market in some other way. I think it's relevant to just kind of also look at that landscape. And I also wanted to add my comment on minority shareholding, and maybe I'll just pass the innovation question on. But I just wanted to add one thing about AI markets, because I think AI markets are pretty illustrative of a lot of the things that are happening right now and why the merger guidelines might be important. And I think that on kind of minority shareholding, for example, there are at least two very salient examples that seem to be captured by the guidelines in interesting ways. So the kind of partial acquisition or investment by Microsoft in OpenAI, and also the investment by Amazon in Anthropic, which I think deserves scrutiny because they will lead to, they know not only lead to have already probably led to all sorts of interferences in kind of management decisions, strategic decisions, but also will probably lead to greater control by these big tech companies down the line. So that's interesting. But there's also a kind of a space that is not covered by the merger guidelines, which is a space of engineers, prototyping inventions, and maybe this relates actually to innovation. People say a team of engineers at Caltech or whatever approaches a big tech company and says, we have this really incredible innovation that will really be valuable to your business in this or that way, right? It complements your cloud services or whatever else. We won't build a firm. We're just going to tell you what we're doing. You buy us as a team, and then we build the thing once you've bought us, right? And that happens. That's kind of a strategy. And there are a variety of other things that are happening in the tech industry that do not constitute a merger in the sense that there's no firm acquiring another firm, but there's still the very same phenomenon of the potentiality of a technology that might emerge, and it will probably emerge within the confines of a bigger company because we're allowing those types of transactions to exist.
All right, so this was a nice softball to promote. Ariel and I, last year, we wrote a book on how big tech barons smash innovation and how to strike back. And one of the things that we looked at, what are some of the myths around innovation? And what are some of the things that aren't mentioned about innovation? So on the surface, you look at how much the large firms are investing in R&D. It's quite a bit, both in just absolute amounts and also as a percentage of their revenues. But in digging into this, we find several problems. One of them is that courts don't distinguish between the type of innovation. And that could be whether the innovation is sustaining or disruptive. And then second, courts don't really consider the value or even the value of innovation. And innovation can create significant value for society. You can just transfer money from one group to another, or it can destroy value. And that would be then toxic innovation. And then the other thing is that the courts and the policymakers haven't really looked at ecosystems and the value chain underlying that ecosystem and how that can impact the path of innovation within that ecosystem. And what we found is that the big tech barons have multiple weapons, both to affect the supply and demand of innovation, but also they have weapons to affect even the path of innovation outside of their ecosystems. And there are negative ripple effects from these toxic innovations. So we then, go towards what needs to be done. And one of the things is that we need to look beyond product, this point I mentioned earlier. But another area, and I haven't heard this, and I've got a group of economists here, and I might as well just offer this. I haven't, this caught me by surprise. They said, what is attributable to innovation in terms of, and that hasn't been really discussed, and it's the role of cities. And everyone assumes that, we just give money to the innovator will innovate. But there was this one book that looks at, it's called Scale, and it looks at how as cities get bigger, you get much more innovation. in that city. And it's actually like a city doubles in population, you'll get more than double the number of patents. Firms, on the other hand, as they get bigger, they'll have more innovations, but it declines significantly. And one of the things is like, why isn't anyone looking at the role that cities have in promoting innovation? You see it in the business literature with like Michael Porter in these clusters, but in antitrust circles, I mean, this really astonished us. So, you know, in getting the feedback from the book, two things that we heard. One thing was from the innovators, and they said, yeah, and there are other weapons that you haven't addressed, and these are how they're being used. But then the other thing is you know, it's like, yeah, isn't this unusual about cities? Why isn't anyone looking at it?
All right, my last question's for Jack, and then I'll open up to audience questions. They're still sitting up next door for refreshments. So if I'm an investment fund, you're asking me to do an antitrust analysis before I invest, are you not? You're asking me to define a relevant market, which I might not have any clue of since it's a legal function?
Yes, well, as Eric pointed out in his article, the agencies, if they're serious about this, can give funds an idea of where the basic, what they could do is set priorities and identify the relevant markets in these priority areas to give the funds the guidance they need.
And those identified relevant markets would not be used in future litigation?
Well, the idea is that they would approximate what would be used in future litigation, because it's a fair question, as I suggested to you earlier. The funds aren't antitrust experts, but the agencies are.
All right, questions from the audience?
So this is more of a comment, but very interesting panel about cities and innovation. So one of the interesting things about cities is that population density, you know, the research has shown is related to monopoly power. And so for workers, as the city gets bigger, there's more opportunities, and that might particularly be true for knowledge workers. That might be one channel. And then the thing about common ownership, obviously we have common ownership in the guidelines for a reason. I can assure you we're looking at it. And you know, things have happened that you may not be aware of, but there is public knowledge about something that's related yet different, which is a systematic enforcement of Section 8 violations, which we had a very systematic program of weeding out, you know, directors who sit on boards of competing companies, and that hasn't been done before. We've really done a big push. We're very successful in that area.
Martin?
Maurice, in your research, you find that the type of innovations that are happening are different when nascent firms are looking to be purchased by big platforms, as opposed to a situation where maybe we prevent some of these mergers, they have to really. Is the type of innovation different?
Well, the oddity is that we call them the tech pirate. They don't necessarily start out like saying, I'm going to disrupt an ecosystem, right? Because that can be really dangerous also, because you're not going to get the funding. I mean, the venture capital firms have pointed out that if you're going to disrupt like Google or Amazon, good luck, but we're not going to fund you. So that could be then sort of like, I'm going to offer a sustaining innovation, but then to what extent then does a sustaining innovation sufficiently attractive that they want to then be acquired? What instead might happen is it's like the accidental disruptor, like Clay Christensen kind of points out, that they don't know necessarily they're going to start off being disruptive, but in turning, like they're not wedded to the current value chain, so they can operate outside of it. But then incrementally, they start finding that they can have then adverse effects. And that would be like WhatsApp, because WhatsApp didn't start out saying we're going to take on Facebook, but then through incremental changes, it then became a disruptive threat. So that, I mean, I don't know. I mean, there was also another study, isn't there, that shows that once one firm is acquired, that they're not necessarily going to buy other nascent competitive threats. There was like an economic study. What was it? Luigi, I think, who might have done that. We cite him, I think, I can get that.
Going once? Going twice? Okay, well, I'm going to turn it over to Hal after we thank our panel. Thanks, guys. A wise person once told me never to stand too long between a conference goer and her cocktails. So this closing remark will be very short. I promise, I think 3.5 minutes to be precise. This is our third competition event since I joined the department at the University of Utah. The first was in the fall of 2022, featuring Lena Khan. The second was in the spring of 2023, featuring Alvaro Bedoya and Jonathan Cantor. And if you missed those, you can watch the video at the Utah Project webpage. And the Utah Project is devoted to the study of both antitrust and consumer protection, as our banner suggests. So it's high time we switch to a consumer protection event, and we are planning one for the fall of 2024. I'm just going to thank some people, and I promise getting off the stage. First, I want to thank Mark Glick of the Economics Department, who is the architect of the Utah Project. Mark's sitting down here, and he brought me to Utah. Mark works tirelessly to organize these conferences, fretting over the smallest details, from arranging vans to moving our speakers from the hotels to the venue, to the audiovisual equipment, to securing the alcohol license at the Alumni House, which is very important. I realize I am standing between you and your alcohol. Mark is assisted by Ginger Zamora, Mickey Escamilla, and Naomi Cruz, who ensured that every detail was just perfect. So can we just take a second, please, to thank Mark and his crew for putting this together? I also want to thank the panelists, who are the real stars of the show, for making the trek to beautiful Salt Lake. I recognize you are in high demand, and taking time off from your busy schedule can upset students, family, and your work bosses. But we wouldn't have an event if it wasn't for you. And in many industries like this one, the workers are the product. So I also want to thank you guys for coming here. I want to thank the moderators, Amanda Lewis, Darren Bush, and Mark Glick. I can't thank myself. Finally, I want to thank all the contributors to The Sling, which is the Utah Project's competition magazine. We launched The Sling on October 20th, 2022, about a year ago, and we've ran 52 pieces. I don't know how that worked out, but it makes the math really easy, about one per week. These are competition pieces. I'm not sure we can keep up this pace, but please keep those submissions coming. Just this week, we ran a piece by Brian Kalachi and Sandeep Vaheesan, who are brilliant writers and could really publish anywhere. In fact, Brian published the same week in the Atlantic. So he did the Atlantic and the Sling. I told him that was quite a week. And it means so much to me that they would think of us as an outlet. And I would encourage everyone who spoke here and everyone in the audience to consider contributing to the Sling as well. Finally, just let me thank Darren Bush, who publishes frequently in the Sling and co-hosts the podcast with me, The Slingshot. If you have any ideas about who would make for a good guest, you should let me know. And thanks to Ted Tados, who was here and will be coming back. He got busy, but he also publishes frequently in the Sling, and runs the data-intensive Slingbox page. So can we give the contributors to the Sling a quick round of applause too? Thanks for making that possible. So that's really all I wanted to say. I think that we're very shortly going to transpire and move over to the happy hour. And we have a few minutes to stretch our legs. But again, thank you guys for coming out here, and really appreciate it. And we'll see you at the next show. Yeah, it's next door.
Okay.